All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Thomas J. Christensen presiding.
Please be seated, everyone. Thank you. Welcome, everyone, especially our guests in the back. Understand we have our externs here today and law clerks and young Mr. Osterbauer, welcome. And again, welcome to council as well, to the Minnesota Judicial Center for Oral Argument before the Minnesota Workers' Compensation Court of Appeals. Today's date is January 26, 2026, and the court has one scheduled case for oral argument. Kristopher Humble versus North Central Service, Inc. and EMCASCO Insurance Company, our file number WC 25-6618. Today's argument is being live streamed and recorded. We would ask counsel to speak loudly and clearly when addressing the court this morning. The panel for today's argument are to my left, Judge Deborah Sundquist, and to my right, Judge Catherine Carlson, and myself, Tom Christensen. We have experienced counsel before us today, but as a reminder to each, you are allowed 15 minutes to present your argument with a yellow light going on when 2 minutes of time remain. At the beginning of your argument, you'll each be allowed 3 minutes of time before I interrupt your argument to ask the panel if a member has questions for you. Counsel is requested to keep track of the time allowed for their oral argument. Any unused time may be reserved for rebuttal. Should the allotted time to a party be extended because of questioning by the court, opposing counsel's time will also be extended. When you step to the podium, please identify yourself and the party you represent. And with that, I think we can begin. And Mr. Harper.
Thank you, Your Honors, Counsel, and may it please the court. I'd like to reserve 2 minutes of rebuttal time. My name is Benjamin Harper. I represent the appellant or petitioner in this case, Kristopher Humble. Your Honors, this case presents a very narrow jurisdictional issue. The award here does two things that Minnesota law does not permit. First, it adjudicates the rights of North Dakota WSI, stating that they may not collect or attempt to collect against any party. Second, it determines and states that the employee may not seek workers' compensation benefits in any other jurisdiction. Under Johnson v. Young and David Drywall, as well as the Gruba case, the judge lacks authority to enforce either of these provisions. Party agreement cannot confer jurisdiction on the compensation judge. Because the award exceeds the judge's jurisdictional authority, it is voidable under Sondrel. If the court then determines that we move to the equities in this case, there is clear prejudice against the employee. The parties relied on North Dakota workforce safety and insurance being extinguished in this case. The employer and insurer were given a credit for the amount North Dakota WSI paid. And in the event this court determines that this stipulation is enforceable and stands as is, the employee then faces double recovery, whereas the employer and insurer get the full credit of North Dakota WSI's interest. In the event the court seeks to sever the troubling language or the jurisdictional defects in this case, that double liability will just be reinforced. Alternatively, this award should be vacated based on mutual mistake of fact. The parties, again, had unequivocal language incorporated in not only the stipulation for settlement, but the award, indicating their reliance on the extinguishment of North Dakota WSI. There is no conditions or qualifications. It states that their interest should be quashed as a matter of law. It does not pertain strictly to procedural intervention interests. There's no conditions or qualifiers. There's no question that the language set forth in the stipulation and award affects the substantive rights of North Dakota WSI, and the parties mutually relied on that. Further, even if this court were to define or find that this was a unilateral mistake, as the insurer asserts, that does not cure the jurisdictional defects that are present in this case.
You're at the 3-minute mark, and it looks like you're going to pause just for a second. So I'll ask the panel if they have any questions for you at this time.
Hello? Okay, there we go. Thank you. Yes, Mr. Harper, thank you. You're correct in stating that it appears that the parties here relied on the extinguishment order that was signed by the CJ. My question to you is, what responsibility do you have as practicing attorneys understanding the workers' compensation law, knowing that the judge was outside of his jurisdiction and allowing this to happen?
Well, it's very clear that party agreement does not confer jurisdiction on the judge.
Correct, but you're both practicing lawyers. You understand the law in the state of Minnesota workers' compensation area. You're both fairly knowledgeable in that area. You knew that the judge did not have jurisdiction over this. You had to know based on case law. So you both entered into this agreement. You both saw what the judge did. I mean, where's your responsibility here?
Well, our intention was that the stipulation would act as agreed, that North Dakota WSI would be extinguished and they would be prohibited from asserting their rights in another jurisdiction even. This is unqualified, unconditional language that clearly states their rights are quashed as a matter of law, no conditions. So our assumption was that the stipulation would act and the award would act as the judge signed, as the language, by the plain language of the statute clearly outlined, and not only, not until my client was sued in North Dakota District Court did we realize that that language was not effective.
But you knew that the judge did not have the authority to do that, did not have the jurisdiction to quash another state's intervention right, correct?
Well, I believe you're making an assumption based on our knowledge, but I mean, if we put forth language to a compensation judge, even if we agree, that does not confer, that does not make, cure the jurisdictional flaws in this case. And does not, the parties can't agree to give the judicial, the compensation judge additional jurisdiction. So while I understand your question, I think it's fairly irrelevant because in that case, the parties would be able, for instance, in an excess fee situation, the parties both agree an excess fee is prudent. That doesn't absolve the judge from his jurisdictional authority, and it doesn't expand jurisdiction for, to the judiciary.
All right, thank you.
Is my mic on?
Yep.
Thanks. Okay, can everyone hear me? Thank you. Mr. Harper, looking at your settlement demand, well, first of all, let me ask you this. You say that the employer and insurer were given a credit, or they would get a credit, or they would get a double credit. Do you mean by you that you and your client gave them the credit? Because I think you mean in your settlement demand, you're not claiming past benefits, you're claiming future benefits. So is that what you mean by giving them a credit?
Not only that, but in the language in the stipulation also applies a credit. And I believe in the briefs, there's also a reference to a pretrial statement by counsel stating that whether the North Dakota WSI payment should be treated as a credit. And that was something that was understood by the parties at the time of settlement, that not only would North Dakota WSI be extinguished, but that the workers' compensation insurer would receive a credit for what had been paid.
Right. So your settlement demand did not include any past amounts. But I read the stip as saying, as part of your claims, that your client was entitled to wage loss benefits from and after the date of injury. So back to October 2022, right?
Correct, Your Honor.
Okay. I think in a nutshell, my question is this. I feel like both parties did some amount of tap dancing, that you knew it was very clear that the North Dakota claim was out there. The law regarding jurisdiction is clear. I definitely understand your jurisdiction argument and that this is potentially avoidable. My question is, how are parties with out-of-state potential intervention claims ever supposed to settle their claims in Minnesota, given your arguments?
Well, the language of the stipulation should be clear and the understanding of the parties should be clear. Here, the stipulation language is unequivocal. It is not conditional. It is not limiting only procedural intervention claims. It is all-encompassing and affects the substantive rights of the party. That's the difference. It should have been narrowly tailored in the stipulation to be consistent with the law. This is not consistent with the law. The order is not consistent with Johnson and Gruber.
Well, and to Judge Sundquist's point, the law hasn't changed since the stip was filed. The law was the law before the stip was filed. So to me, it feels like the parties are tap dancing a little bit to say, well, we kind of knew what the law was, but we're going to try to have this go through anyway. And I agree with you that this is not what was intended for you or your client, but would you agree that it's still predictable? It's still predictable that the situation was going to happen?
At the time of settlement, it was not predictable that North Dakota WSI would ignore and disregard an order from the compensation judge. We were under the impression, and the language can have no other conclusion, that we were under the impression that the compensation judge had authority to quash as a matter of law North Dakota WSI's intervention interest, as well as bar them from collecting or attempting to collect against any party.
Well, then let me ask you that. Is that then a mistake of fact or is that a mistake of law?
It's a mutual mistake of fact. Well, and it's a mistake of law, frankly.
Is mutual mistake of law a basis to vacate a stip?
No, not necessarily. The mutual mistake of fact is key here, because the fact was that in settlement negotiations, we both relied on the extinguishment of North Dakota WSI in reaching our agreement. But more importantly, the first issue should be jurisdiction. The first issue is whether the judge's order violates the jurisdictional parameters set forth in Johnson and Gruber. And here it clearly did.
I have a question. So the jurisdiction would not only apply to the WSI, but also to the out-of-state interveners who appear to be from North Dakota and Oklahoma. Am I correct in that assumption?
Correct, Your Honor.
Given if we determine that the stipulation, we don't have, this court and or the compensation judge don't have jurisdiction over the WSI and these out-of-state interveners, what impact does that potentially have on the court for other stipulations for settlement where the compensation judge may have extinguished or quashed the rights of out-of-state potential interveners in a stipulation for settlement? Just because we can do something, should we do something, and how should we handle these things in the future?
Well, we're asking for a very narrow holding here. We're simply asking the court to enforce already existing law. That's what we're doing. And this is a very unique situation in which not only an out-of-state provider, but an out-of-state government entity is at play. And that government entity paid benefits. So it's a unique situation.
So what is exactly what you're asking us to do?
I'm asking you to vacate the award on stipulation and remand the proceedings to the Office of Administrative Hearings for further review.
And what purpose would that serve? I mean, the remand itself.
Yeah, well, it would allow us to take into account North Dakota WSI's interest, take into account that the Minnesota Court of Workers' Compensation Judge does not have jurisdiction to quash or prohibit their interest, and it would have to be in consideration when we're making further decisions on adjudication.
Regarding the jurisdictional issue, is this a case that where we should void the award, or is it a voidable award?
Well, it's voidable. It's voidable for the clear jurisdictional imperfections and jurisdictional violations. And then if we go to equities, I think that's abundantly clear, given the double liability on my client. And under Sondrel, that's the proper way to proceed, is we go to, it's a voidable award based on the jurisdictional flaws, and then we take into consideration the equitable factors in the case.
And just looking at the payments to the WSI, in looking at the materials that were sent to us in the materials, it looks as though the WSI made a determination that your client was eligible for those North Dakota benefits, which were accepted, both wage loss and medical. Would you agree with me on that?
Correct, yes.
Okay, so he was paid those benefits, and in looking at the materials, it looks like the employer was charged somehow or another for the benefits that were being paid to your client. So I'm trying to figure out how there's somehow a double recovery because your client received the benefits and the employer appears to have paid those benefits.
The settlement agreement only pertained to eligibility for future benefits. At no time do we consider the work comp insurer's obligation to pay for benefits that had already been paid under North Dakota law.
Excuse me, but Mr. Harper, the stipulation for settlement specifically closes out all past, present, and future claims. So, and that's where the confusion lies, at least for me. If the stipulation had been drafted in such a way that it closed out only future benefits, would we be here right now?
That's tough to kind of anticipate how that would play out. And the reason is because it's, in this case, every ounce of settlement negotiation, every conveyance by the party, every interaction assumed that there would not be an obligation by the new work comp insurer in Minnesota to cover the benefits previously paid. That the way to rectify that was to notify North Dakota WSI of notice of their right to intervene. And if they failed to intervene, they would be extinguished. And that's how it plays out in so many of these cases, whether it be a long-term disability provider, the Department of Employment and Economic Development. That's how we treat interveners. So when we're notified that another party has a potential interest in our case, our obligation under the statute is to notify them of their potential right to intervene.
Mr. Harper, is there any significance to the fact that the jurisdictional argument that you're making, this North Dakota, potential intervener, a nexus between that and what has happened to your client, the claim being made against your client? To you, is that significant that the reason that you're here is the North Dakota thing and now North Dakota going after your client? Can you talk on that, please?
Of course, Your Honor. I mean, the lawsuit in North Dakota is what triggered this action, because before then, we understood the STIP operated as the parties intended, that North Dakota would pursue no further recovery and would be barred from doing so as a matter of law based on the plain language of the stipulation and award.
Go ahead.
So your client was prejudiced in what way? I want to hear it specifically from you.
Yeah, my client was prejudiced because if the award stands, what we have is that my client already provided a credit and diminished the amount of his settlement and the benefits he was claiming by the amount that WSI paid. The employer received a credit for those benefits. And now my client faces liability in another jurisdiction for those same exact benefits that the employer and insurer were credited.
Thank you, Mr. Harper.
And how does that play in, though, with the hold harmless clause, where it seems within the stipulation for settlement that your client recognized the receipt of the benefits from North Dakota and agreed to hold the employer and insurer harmless from any claim made with respect to those benefit payments?
Well, what that hold harmless language says, well, what it does not say is not say that my client will be responsible for any payments to North Dakota WSI. We interpreted that as dealing with North Dakota if they should have any questions about the extinguishment language. And again, more importantly, jurisdictional defects are not cured by waiver or consent. So it does not cure the jurisdictional defects that language is incorporated into the stipulation.
And then my final question for me anyway is, with respect to your client, has there been any attempt by these extinguished or quashed interveners to go after your client for any of the medical benefit payments that may have been made by the WSI?
Yeah, the WSI itself is the only party to have filed suit or attempted to collect against my client.
Thank you. Now, we've kind of used up your 2 minutes of rebuttal time, but
I actually have one more question.
go ahead.
Thanks. Mr. Harper, your reply brief, you state that this court has authority to vacate voidable awards that rest on an erroneous understanding of the law. And I summarize that just a little bit. My question for you is, does that erroneous understanding need to be mutual? And if so, how do you prove that the other side also had this erroneous understanding of the law?
Well, it's really understanding the court's jurisdiction. And in Sandro, we know that the court's jurisdiction is limited to quashing procedural intervention rights only, not substantive intervention rights. And exactly what the stipulation and award do in this case is do just that. They quash substantive rights, which is impermissible. And that's what I'm referring to, that this court exceeded the jurisdictional limits, and for that reason, the stipulation should be vacated.
Thank you.
Thank you.
Mr. Weir? So we went over by about 3 minutes and 30 seconds, so why don't you, 18 minutes? Or you have up to 18 minutes.
I was
I'm
gonna
not
say-
saying you have to use all 18 minutes.
Talk about the weather here. No, I see I got 18 minutes. I'll follow it here and I'll try to use it wisely, I promise. Thank you, and may it please the court. My name is Chris Weir, and I'm one of the attorneys for the respondent, North Central Services Incorporated. The compensation judge did not exceed their jurisdiction by extinguishing North Dakota WSI's intervention interest for failure to intervene in this workers' compensation claim. The arguments forwarded by the employee that the compensation judge's extinguishment was an adjudication of those rights in its home jurisdiction of North Dakota is at odds with our established rules of procedure, statutory framework, and case law. The award here goes no further than the jurisdiction conferred upon to the compensation judge. Instead, the petition to vacate seeks to undo a settlement agreement between the parties that was found to be reasonable, fair, and in conformity with the Minnesota Workers' Compensation Act. Despite how the employee asked this court to view the facts, the process was fair. This was a negotiated settlement between two represented parties. It was done so with the help of a compensation judge at a court-mandated settlement conference. A draft stipulation for that settlement was provided and accurately reflected the terms of the parties' agreement. The employee and counsel had ample time to review the agreement, raise objections, or request changes, but none were done. The employee and counsel signed that agreement, assenting to its accurate reflection of the terms, and requested the compensation judge issue the award for its approval. Even when the court approved the award or approved the stipulation for settlement, provided the award, no objection was raised. Once the settlement proceeds were accepted, no objection was raised. As the court has pointed out, the only objection came once the, North Dakota WSI came and sued the employee to recover those benefits. This was something that both parties knew, but particularly the employee when he switched and pursued Minnesota workers' compensation benefits. The jurisdictional argument here, along with the claims of mutual mistake, arise from the same unilateral mistakes by the employee and counsel and the understanding of the extent of 176361 and the extinguishment clause that the compensation judge put in the award. These are not consistent with the established rules of procedure, statutory framework, and case law, and I believe the petition to vacate here should be denied. I'll pause here and see if the court has any questions.
Any questions?
I do. Counsel, you agree that the Court of Administrative Hearings does not have jurisdiction or legal authority to foreclose NDWSI's claim?
Yes, but I'm going to qualify that as a good lawyer might. Here's where I think we're differing is the extent of what that extinguishment did. And here's how I built this. Under the rules, the parties are required to put all potential interveners on notice. Parties are required to do that regardless of who that might be, out of state, in a state. Under the rules and the statute, those parties, absent an expedited hearing, has 60 days to file a motion to intervene to assert and protect that interest. If they do not, the statute then says that upon that failure, the compensation judge or the body shall extinguish that interest rate. Now, when you look at the award and extinguishing it, we are not alleging or even arguing that the award goes outside of the Minnesota workers' compensation system. That is kind of the assertion from the employee and counsel, and that's where we think that the unilateral mistake came from.
Well, but Mr. Weir, I mean, the plain language of the award, and I understand this was sent as a Word document to the judge. I don't know that the judge altered it anyway, but it does mirror the language in the stipulation. It doesn't say procedural rights are quashed. It specifically says quashed as a matter of law as against the employer and insurer herein and as against the employee herein, and said potential interveners, including North Dakota WSI, may not collect or attempt to collect their interest from the employee insurer. That goes way beyond. So I understand you're saying no, just the procedural rights, but that language to me is very different than procedural rights.
Where we're pushing back on this is that it doesn't actually adjudicate North Dakota's, the rights in North Dakota. I think that if for some reason NDWSI comes into Minnesota, tries to reopen the workers' compensation claim, that language would absolutely be upheld. The compensation judge does have the authority in the jurisdiction to do that. I don't think where we're building this, right, is based on the understanding of the authority of the compensation judge, right? The workers' compensation court is not a court of general jurisdiction. It's only applying, analyzing, and making determinations on Minnesota workers' compensation claims. So to the extent that the jurisdiction conferred upon the workers' compensation judge at the time was just to the Workers' Compensation Act. And the reason we're kind of getting into 176361 in that extinguishment language is it actually isn't clear from the statute about how far that goes. And when you actually look at some of the cases that we have here, and I apologize, it's either Johnson versus Concrete Treatments or it's Johnson versus the Office of Administrative Hearings. But the courts, while they were talking about direct reimbursement claims by employees, go through the list of, why 176361 is there. Why, do we have these things? But then they also talk about the legislative history, right? And in those, they know that the purpose of that language is to basically take those interveners out of the workers' compensation claim so the parties can move forward with settlement, with hearing, with those disputed issues on the expedited basis, right? So when you put all these things together, the compensation judge did not have that authority to adjudicate in North Dakota, and we would push back that the compensation judge did not do that based on the award.
So, Mr. Weir, what I understand you saying is that you and your client understood the extinguishment language to be procedural or perhaps substantive, but only in Minnesota, and that Mr. Harper and his client is reading it differently as being what it says on its face. You can't come after my client and try to reimburse this money. Is that kind of a fair summary of what you're saying?
Yeah, it's basically you're reading the same language and you're coming to, what applications. And obviously, there was lots of question about the responsibility of counsel and understanding the case law and how this procedure affects. But when you look at Johnson, when you look at Gruba, and obviously several cases that this court and the Minnesota Supreme Court have addressed with interveners, is that the understanding with practitioners in Minnesota is when you have these out-of-state interveners, the stipulation of the court doesn't have a jurisdiction to adjudicate those rights, and that's not what the intent was with this.
So is that a mistake of law then, or mistake of fact, or some mix of fact and law?
I think for this, when you think about the procedural effect and I guess the legal effect of the extinguishment, it would be what we would say a unilateral mistake of law, not a mistake of fact. Because I think the fact is the same. We put them on notice. They didn't intervene under the statute. 60 days passed. We asked the court to extinguish them. That's the facts here. I think it's the legal effect there.
Are you aware of any type of, is there case law that you're aware of where a unilateral mistake of law allows for us to vacate under 461?
Not that I'm aware of, Your Honor. When I see one of the cases we cited here was the Shelton case, right, where there was a unilateral mistake with the attorney improperly advising his client of the procedural effects or the legal effects of closing out interveners in the stipulation, right? Those interveners still came back and sued the employee. He basically came through, and the facts suggest that his attorney did not properly apprise him of those legal effects. There wasn't a mutual thing. So I think in terms of that unilateral mistake, it would probably be one of law, what the application was. But then I suppose there's somewhat of a fact, as in the employee didn't really understand what the stipulation said and what the implications were. But I believe that still kind of goes on to the advising portion of what were they told? What did they understand about the legal implications? So no, to your question, I don't know of any case of a unilateral mistake for voiding the agreement.
Mr. Weir, I'm going back slightly to what Judge Carlson asked you. Did the compensation judge here have jurisdiction to bar the North Dakota WSI from collecting or recovering benefits from the employee?
In Minnesota, pursuant to the Workers' Compensation Act, yes. But in terms of adjudicating in North Dakota, no.
So the compensation judge did or did not have jurisdiction only in Minnesota. Is that what you're saying?
Only in Minnesota, correct, Your Honor.
And this was language that you had written, your firm had written in the award. It was a proposed award that basically the compensation judge used in the actual award, correct?
I believe so, but we've included both the proposed award. I believe that's I got here's Exhibit 9, I believe. We've included both in our exhibits, and you can see that the compensation judge actually does make substantial changes to that. I mean, he uses the same language, but if for certain practitioners, it's fairly common language to see in STIPs.
Yeah, and as far as the language concerning the barring and the inability to recover any kind of collection or money from the employee, that is pretty much the same language, correct?
It's the language that's included in the statute. It's not like a particular or subset that we've created.
Okay. Do you think that the language that was in the award, the proposed award and the actual award that the CJ signed was prejudicial to the employee?
Not when you consider that you have a represented party negotiating that for him. So again, there's this idea that there's this mutual mistake as to the effect of the extinguishment of NDWSI. And when both parties understood the law, understood kind of the implications of that, it's on the employee and their attorney to basically understand those implications. And obviously, when you look at these cases, and practitioners in Minnesota know this, when we have these out-of-state interveners, special care has to be taken, right? And in this case, I mean, this case was basically a jurisdictional quagmire. Oklahoma resident, North Dakota injury, Minnesota employer, right? You had to make those assessments at the get-go. And so the prejudice is prejudicial to the employee, but it's not prejudice that supports a vacation of an award.
So, Mr. Weir, going forward, how should parties draft their stipulations for settlement and the proposed awards on stipulation in cases where another state has, obviously they're not within the Minnesota jurisdiction, another state has interests in the resolution of the work comp claim?
Your Honor, I think when we look at the cases, whereas, our court can't order reimbursement for out-of-state interveners such as like North Dakota, right, when their rights arise under their own workers' compensation law. The court can't offer that like direct payment as that either. I think what happens, or what has to happen, is that it comes down to the negotiation table. Basically, when parties are dealing with these out-of-state interveners, it's up to both parties to essentially fashion a resolution to address that, right? You asked Mr. Harper questions, what if the benefits weren't, was only future, not past, would we be here, right? That would be a consideration in terms of drafting. Would we be here if for some reason the stipulation said, the employer insurer will pay North Dakota WSI 10% of whatever its bill was, right? I don't think so. I think it's up to the parties. And when you look at the stipulation for settlement, we directly asked for something that would address this portion in the negotiation, asking for the hold harmless language. And so that was addressed by us, right? We asked for this, is that we understood that North Dakota would have this interest. There was a possibility they would sue the employee for those benefits. And we negotiated that a part of the settlement is that the employee would hold us harmless if they brought that suit. There is this argument within the briefs that the employee only understood that to be I only had to communicate with North Dakota WSI. I didn't actually agree to be liable to them. But I don't think any court, not even this court or any general jurisdiction court, would look at an indemnity clause or a hold harmless clause and say that was the legal effect. I think that also shows, again, another unilateral misunderstanding of the implications of the law and the stipulation and the terms.
So, Mr. Weir, and it's what you said that troubles me, and I have a question after this comment as well. The stipulation provides for the language that is very arguably brings us to a jurisdictional issue with closing out North Dakota's claims. I know you say it's just procedural, but then there's also the hold harmless. So it's like the stip is kind of, again, tap dancing. We understand this might be an issue. So here's my question. How do you differentiate this case from Milner versus Schwanz?
Absolutely. I'm glad you asked that. So in Milner v. Schwanz, the petition to vacate was on a mutual mistake of fact, right? And we have similarities with that case. Out-of-state intervener didn't respond, extinguished, award, and a lawsuit afterwards. The differentiating piece of that case that was left out of the brief is that the two parties collectively took that award, went to Hennepin County, asked for that to become a judgment in Minnesota to be enforceable. When they failed, basically then the petition to vacate came for that. And so the differentiating piece here is that there was evidence of that mutual mistake. I know you're talking about this tap dancing, but the tap dancing is the understanding of the law and the legal effect, right? And obviously in our view, when we argue that, you can't adjudicate North Dakota rights and that was not the purpose here, that's one interpretation. Then, there's another side over here. But in that case, there's actual facts that show both parties understood that was the case and that's what they wanted. And obviously they were both wrong. And then the petition to vacate came through. And so I think there's this indication that if the court thinks that there might be a mutual mistake here and there might be some kind of question of, what was the employee told, what was the employer told, and how did this all come together? I think that's not evidence in the record. We don't have those facts.
But the fact that this closeout provision was in the stipulation for settlement means to me that both parties thought that that would be the effect of it. So you don't agree that that is some type of mutual misunderstanding, whether a fact or of law?
Possibly of law if that's what we are arguing. But again, we're only arguing that the extinguishment went as far as the Minnesota Workers' Compensation judge could go in terms of they have the authority and obviously the obligation under 176361 to extinguish those potential interveners who don't show up right in the case. So to the extent that they extinguish that right to intervene at the Workers' Compensation Act, they had jurisdiction to do that. And so, yeah, that would be our interpretation of that extinguishment language. And when we put in the hold harmless, that was showing we still think there's a possibility the employee is going to be sued for this. And if that's the case, we're negotiating this hold harmless language as part of the overall settlement. And just to be clear, this is, something that was described as a very narrow appeal. And it really is, right? We have basically a full agreement that goes back all the way to the date of injury, resolving all benefits, making assertions of not only these credits, but obviously claims and defenses in the case, the jurisdictional disputes, and the parties came to a similar settlement to resolve the entire claim on its face. And so to the extent that one tiny portion of the stipulation, is particularly voidable, you look at the overall intent of the stipulation was to resolve the claim on a global basis, and that was essentially achieved, right? Just pursuant to this jurisdictional dispute.
And you'd still agree, we have no jurisdiction to deal with North Dakota WSI's pursuit of the employee in North Dakota. You're just saying here.
Correct. And
Same thing with the interveners. You'd only deal with something in Minnesota, not in Oklahoma or North Dakota. Or if I'm understanding what
I would say that the medical providers are different because they can come into Minnesota and be subject to the fee schedules. I think if you look at the case law, especially Johnson and obviously Gruba, the problem arises when you have an agency whether it's Wisconsin or in North Dakota, obviously, they come in and they're trying to assert recovery under their own state law. That's when the court gets to go over there. So I don't think the issue is the medical providers, because they can come in and be resolved under that. It's the agency. To the extent that this court would allow me to just quickly finish here, I'm at my time. We would just ask that the petition to vacate be denied for these reasons. Thank you.
Thank you all for your presentations, helpful for the court. Matter is taken under advisement. We'll issue a decision in 90 days. Thank you very much.
Thank you.
All rise. Court is adjourned.